Securing Your Freedom, Moorish Liberty from Legal Slavery. Introduction. This research report is provided as a teaching ministry for good and lawful Moors according to the commandments of our Lord and Savior, Yeshua the Christ. But God has chosen the foolish things of the world to confound the wise, and God has chosen the weak things of the world to confound the things which are mighty. 1 Corinthians 2:27. What you're about to learn is not what you've been taught by the status quo, any licensed ABA attorney, or any other purported judicial officer. You will not find this information freely spoken of by those of the modern judicial system, although the legal aspects of this material was verified as accurate by a group of current and former bar attorneys from 3 different states. This material is not a presentation of any legal advice nor the legal practice of law, and should not be construed as such. What we have written here is solely for the edification and education of the true temple of the Christ Yeshua. While the Moorish people has slept in legal ignorance for many decades in America, our publication of this material is to teach the truth to those of the body of true Christ, his or her body temple. Instead of tracing the steps that lead back to their sources and little errors at the beginning, modern thinkers have tried in other ways to circumvent the result of the initial errors, often compounding the difficulties instead of overcoming them. While studying the material we have presented here, we caution you not to continue past any sentence unless you understand the legal definition of each word. This includes even the simplest common words as well as the many legal terms you will encounter. Keep in mind that what is legal is not necessarily lawful, and that modern commercial law is not Allah's law. When you find any word that is not absolutely 100% clear in your understanding, go to the Lawgiver Reference Library and consult all the dictionaries listed there. Do not presume that the definition of any term or word as you know it is how the law dictionaries define the same word or phrase. You'll be amazed at the differences. For example, we've been taught to believe that an elopement is when a man or a woman, or both of them, secretly runs off to marry without family approval or knowledge. Not so. According to a dictionary of law, elopement is the act in a wife of voluntarily leaving her husband to live with another man. Bouvier's Law Dictionary says, this term is used to denote the departure of a married woman from her husband and dwelling with an adulterer. Never take any word for granted until you look it up. Some of the important key words and maxims of law you will need to fully understand before beginning are commerce, Latin, commercium, in its simplest signification, an exchange of goods, but in the advancement of society, labor, transportation, intelligence, care, and various mediums of exchange become commodities and enter into commerce. Gibbons versus Ogden. Marshall, Chief Justice. The inter-exchange or mutual exchange of goods, productions, or property of any kind between nations or individuals. People versus Raymond. What this means in the modern American English language is this: every inter-exchange and exchange between people, including but not limited to marriage, birth, death, and exchange of ideas, intellectual property, and the ordinary buying or selling in the marketplace is legally a part of commerce. A universal maxim of law states, contract makes the law. In the legalized world of man's law in which we live, remember these 3 truths. All law is contract. Every inter-exchange between people is contract. All commerce is contract. Chattel, Old French, chattel, goods, property, from medieval Latin, capital, an item of tangible or intangible personal property. Chattel personal, plural chattels personal, an item of tangible movable personal property, as livestock or an automobile that is not permanently connected with real estate. Chattel mortgage, a mortgage of or against personal or movable property. Source, Merriam-Webster Dictionary of Law, 1996. Things include not only things movable, but something more, the whole of which is comprehended under the general name of chattels, which Koch says is a French word signifying goods, from the technical Latin catala, which meant primarily beast of husbandry, and secondarily all movables in general. Any species of property not real estate or freehold. Source, A Dictionary of Law, 1893. In modern American legal usage, a chattel includes all personal and movable property, including a servant. This places men under the law as nothing more than merchandise. Commercial chattel property includes a permanently indentured servant by contract to an operation of legal commercial law, specifically the Uniform Commercial Code, UCC.
Mercis appellatio ad res mobilis tantum pertinet.
The term merchandise belongs to movable things only.
Mibilia personam secuntur immobilia situm.
Movable things follow the person, immovable their locality. Law. Latin lex, from the root of lay. A law is that which is laid, set, or fixed. Like statute, from the Latin statio, a rule, particularly an established or permanent rule, prescribed by the supreme power of a state to its subjects for regulating their actions, particularly their social actions. Laws are imperative or mandatory, commanding what shall be done, prohibitory, restraining from what is to be forborne, or permissive, declaring what may be done without incurring a penalty. In general, law is a rule of action prescribed for the government of rational beings or moral agents, to which rule they are bound to yield obedience, in default of which they are exposed to punishment. Or law is a settled mode of course of action or operation in irrational beings and in inanimate bodies. Commercial law, or law merchant, the system of rules by which trade and commercial intercourse are regulated between merchants. Source: Webster's American Dictionary of the English Language, 1828. Lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful property implies a thing conformable to or enjoined by law. Legal, a thing in the form or after the manner of law or binding by law. A writ or warrant issuing from any court under color of law is a legal process, however defective. Source: A Dictionary of Law, 1893. Legal. Legalis. Pertaining to the understanding, the exposition, the administration, the science, and the practice of law. As the legal profession, legal advice, legal blanks, newspaper, implied or imputed in law, opposed to actual. Legal looks more to the letter and lawful to the spirit of the law. Legal is more appropriate for conformity to positive rules of law. Legal imports rather that the forms of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed. Lawful, that the right is actful in substance, that moral quality is secured. Legal is the antithesis of equitable and the equivalent of constructive. Second Abbott's Law Dictionary, page 24. Source: A Dictionary of Law, 1893. Uniform Commercial Code, UCC. A comprehensive set of business laws. The idea was to make the rules of commercial transactions, such as the sale of goods, universal. The UCC is a codification of commercial law, adopted in whole or in part by all the states, that attempts to make uniform all laws relating to commercial transactions, including chattel mortgages and bulk transfers. Security interests in chattels are created by an instrument known as a security agreement. To give notice of the security interest, a financing statement must be recorded.
Multi multe, non umnian fit.
Many men know many things. No one knows everything. Part 1. Preface and Background. Preface. Before any reader can understand the following material, you must first know what your legal status is. Status. The condition of persons. It also means a state because it signifies the condition or circumstances in which the owner stands with regard to his property. Source: Bouvier's Law Dictionary, 1856. Status. Latin. Standing. State, condition, situation. A corporation has no status as a citizen outside of the jurisdiction where it was created. Source: A Dictionary of Law, 1893. Status. Latin. Mode or condition of being. From stare, to stand. The condition of a person or a thing in the eyes of the law. Position or rank in relation to others. Source, Merriam-Webster's Dictionary of Law, 1996. For the purpose of this report, you must understand that your legal status is nothing more than the state, condition, and standing you have according to and in the eyes of state, federal, or international law. Of course, this does not agree with your status before the Lord God as a free and sovereign heir of the King of Kings by his warrant and testament and part of the body of Christ, his church. When dealing with this material, you should remember that the world we live in pays no attention to your Christian status or how the Lord God sees you. In this instance, you must remember how the state views your status in their law, or, more accurately, by their legalities. For the time being, you must set aside who you are in Christ Jesus in order to comprehend how the purported law of this world sees you. In reality, the current legal status of mankind in this world is that of commercial chattel property. If you don't fully understand what this is, go back to the introduction and read over the definition again. As commercial chattel property, you are nothing more than a slave and an indentured servant. The lifetime value of your labor and work is considered a commercial asset and legal property.
Catalla giaste possessa mitti non possunt.
Chattels justly possessed cannot be lost. The question you should now ask yourself is this. According to the law and the legalities now set in place as authority above you, who owns your property? In their eyes, according to the Uniform Commercial Code, UCC, you do not hold a sovereign status. They do. Therefore, they hold title to all your property, including your labor. However, in order to gain the status as a legal sovereign, you must utilize their laws.
Ignorantia legis neminem excusat.
Ignorance of fact may excuse, but not ignorance of law. The program being presented to you here outlines the procedures within their own commercial laws that allow anyone to attain a legally recognized freedom and sovereignty.
Nil tam naturale est, quem eo genere quidque dissolvere, quo colligatum est.
It is very natural that an obligation should not be dissolved, but by the same principles which were observed in contracting it.
Qui evertit causam, evertit causatum futurum.
He who overthrows the cause overthrows its future effects. Remove the cause and the effect will cease. It may sound quite absurd that you and all you possess are considered nothing more than commercial chattel property, but this is the legal status you have been given and have allowed the world to place upon you. As you begin to absorb the following material, you will see that the facts support this legal commercial status of your being, regardless of how you think of yourself. There is no place for Christ in the commercial law, the law merchant. Background. The beginning. Since long before the time when Yahshua the Christ walked on this earth, the select merchants of the world, who also control the exchange of money and all barter and commerce, have been building and improving upon a system by which all world law and commerce operate. Let's just call them the World Power Brokers, WPB for simplicity. They base their system on the classic and ageless standards of nothing more than the simple interactions between men and have progressively codified this into man's law. All legal issues, remedies, and disputes deal with one or more of these standards or principles. In simpler terms, all human interexchange is considered commerce. Those select few, the world power brokers, who are operating and controlling this system of interactive law have gained a virtual unlimited control of the world by transforming these foundational ideals and reforming them into legal codes. In the process, they have confused and confounded the people and kept them ignorant of their law and, more importantly, how to use it or apply it properly. The term legalese comes into mind when the average man attempts to decipher these codes, as this is a language he doesn't understand or comprehend. The end result of their efforts over thousands of years is a uniform commercial code. In this day and age, all world commerce operates within the principles of the UCC. The UCC was drafted and conceived by the world power brokers in order to exploit the common man and subdue him. This transforms a man of God into nothing less than a servant and a slave of the merchant masters. With all their worldly wisdom, codifications, and laws, they appear to have achieved an unbreakable code of bondage over mankind. However, a common sense dictates a solution. Since they have based their merchant laws on the same standards of interaction common to all men, the same underlying principles can be utilized by the average man to use these codes to his own benefit and change his status to that of a sovereign. A better way to put this is to say they left the back door open. Now, Let's just see how big and wide this doorway is. There are 10 basic foundations of commercial law. It is from these timeless principles whereby all law and commerce in the world is acquired. Number 1. A workman is always worthy of his hire. This is perhaps the most universal law of mankind. Every society on earth who has denied this maxim of law has suffered wrath and destruction by the masses.
Inutilis labor et sine fructu non est effectus legis.
Useless labor and without fruit is not the effect of law. Number 2. All men are considered equal under the law. While this may not be practiced throughout the world, the underlying truth of this standard has caused great empires to fall and destroyed many kings and monarchs. Number 3. In all interexchange, truth is sovereign and the supreme rule. Interexchange of every kind, from goods to intellect, between men is commerce. In all commerce, the allodial and supreme rule is truth.
Conterre veritatem lex num qua maliquid permittit.
The law never suffers anything contrary to truth.
Nil possumus contra veritatem.
We can do nothing against truth. 4. Truth can only be expressed in the form of a legal affidavit. From medieval Latin origin, affidavit means he has pledged his faith, akin to the word affiant from the Middle French, affire, to pledge faith, swear.
Forma legalis forma essentialis.
Legal form is essential form. 5. A legal affidavit is undisputed truth unless a counterclaim or rebuttal has been made. Since an affidavit is sworn and pledged by faith, it is presumed to be absolute truth unless another sworn claim counters it in rebuttal. 6. An undisputed affidavit of claim becomes final judgment. When one fails to answer or refute an affidavit of claim made against him, the affidavit first presented is considered absolute and true. By not rebutting what has been claimed against him, one becomes guilty by his silence.
Idem non esse et non appare.
It is the same thing not to exist and not to appear.
Qui tacet consentire videtur.
He who is silent appears to consent. 7. All matters must be expressed in order to be resolved. No claim can be made against another unless an affidavit has been presented stating the reasons of law supporting the claim along with the events of the interexchange. 8. The party who leads the dispute first also loses by default. If one walks away from a claim or dispute in commerce, either by silence and default or failure to properly rebut, he becomes an instant loser.
Omnis consensus tiolli terrorem.
Every consent removes error. 9. One must be damaged in some way to make a claim or charge against another. Damages in commerce are always equitable, and a loss of equity must be shown in order to make a claim. In commerce, all things have a commercial value, including intellectual property.
Actio non datur non damnificato.
An action is not given to him who has received no damages. 10. A lien or claim can be satisfied only by award of a counter affidavit, resolution by a jury, or payment in satisfaction. A commercial claim must be resolved by a rebuttal, a jury, or relief to the claim by payment for damages.
Arbitrium est judicium.
An award is a judgment. The players.
Scire debes cum quo contrais.
You ought to know with whom you deal. What we are specifically dealing with here is how the laws of commerce are used against the common man, and just who is behind it. Much has been written and documented concerning the continuing bankruptcy of the United States federal government. Reference to this has been codified in the federal law as a basis for what you are now going to learn. While the world power brokers may not be known by name, this makes no significant difference for the purpose of this material being presented here. The fact remains that the corporate U.S. in Washington, D.C. is bankrupt, has declared this in the federal codes, and the unknown world power brokers are the creditors. Much of this will become clearer as you study this material. The supreme affiant, or the one ultimately behind an affidavit of claim, is known in law as the real party of interest, RPOI. A real party of interest is entitled under applicable substantive law to enforce the right sued upon or possess legal right to enforce a claim. The real party of interest is an actual person. For simplicity, understand that the real party of interest is one of the select few world power brokers. In every commercial claim, they are the unrevealed claimant, the real party of interest behind the U.S. bankruptcy, world government, and the new emerging third way, successor to the New World Order, are unknown to the common man. What is important to retain at this juncture is the method used by the world power brokers to collect their purported claims against you. A real party in interest, RPII, is a front for the real party of interest. In layman's terms, this is called a straw man. Specifically, this straw man is a collector for the lien holder, and collects claims on behalf of the lien or creditor. Certain representatives and agents, including administrators and trustees, are also considered real parties in interest. A real party in interest can be the state of Georgia or any United States agency. Their duty is to collect debts for the real party of interest from the commercial chattel property that has a lien placed against it by claim.
Debita secuntur personam debitoris.
Debts follow the person of the debtor. Part 2. Concepts of modern law will further explain how the real party of interest and the real party in interest operate and how the commercial law enforces their claims. Part 2. Concepts of modern law, origins of the UCC. The Uniform Commercial Code is the supreme law of the world. In other nation states, their codes and laws mirror the principles of the UCC. The United Nations bases their codes and rules on the UCC. There is no major world power that has not codified the standards of the UCC into their national laws. While we have previously written much about the truth of Moorish and Christian common law, these are not the laws of the world system. It's time for all Moors and Christians to realize that the new common law of the earth is commercial law, also known as the law merchant. While God's law cannot be erased, it has been subdued and slowly replaced by a legal common commercial code. This has come about as a result of complacency and ignorance on the part of good and lawful Moors and Christians.
Currit tempus contra desides et sui iuris contemptores.
Time runs against the slothful and those who neglect their rights. We've allowed it to happen and have even blindly supported it. You must deal with the source of the earth's law in order to find the solution. Thomas Jefferson said, "Those who expect to be both ignorant and free are expecting something which never has and never will exist." As interstate commerce and individual movement dramatically increased in the U.S. after 1865, the world power brokers felt a need for greater uniformity of their law. An approach known by the common name Uniform State Laws was founded to seek adoption of identical or similar laws to be utilized by all the federalized states. The National Conference of Commissioners on Uniform State Laws, NCUSL, was formed in 1892 upon the recommendation of the American Bar Association for the purpose of promoting uniformity in state laws on all subjects where uniformity is deemed desirable and practicable. Made up of ABA lawyers chosen by the federal states, the conference still oversees the preparation of proposed laws, uniform laws, which the states are encouraged to adopt. For over a century, this process has been carried out through selective ABA committees that prepare drafts for review and ultimate approval by the full conference and has continued to function. For reports on the current projects of NCUSL, click here. To date, the commissioners have approved more than 200 uniform laws. Most have been widely adopted by the federalized states and have, as a consequence, initiated uniform federal law throughout the states. The greatest success of the uniform law approach have been in the field of commercial and business law. Beginning with the Commissioner's first product, the separate Uniform Negotiable Instruments Law and Uniform Sales Act, the conference, working together with the American Law Institute, later produced the Uniform Commercial Code. The UCC was brought to its present form by the NCUSL and the American Law Institute in 1978. It has been improved and revised numerous times since then, with major revisions in 1987, 1988, 1990, 1991, 1992, and 1994 in order to universally apply to all the federal states. With the exception of Louisiana State, the UCC has been pretty much adopted in its entirety by all the remaining 49 states. As a side note, it's not just the commercial law that has been made universal. Downloads are also available for the Uniform Probate Code, Uniform Code of Evidence, and uniform laws in the areas of matrimonial, family and health, and business and finance. If you are unclear about what uniform laws exist, see the Legal Information Institute Uniform Laws page. These uniform laws reach far into the private interactions of mankind, right down to marriage and family. All are based in one way or another on commercial law. As a Christian, if you don't believe these earthly laws have authority over you, then stop right here and research every link provided to you above. Your life on this earth is presently controlled by these universal laws. In order to free yourself from this, you must understand them first.
Optimus interpretandi modus est sic legis interpretare ut legies legibus accordant.
The best mode of interpreting laws is to make them of one accord, uniform. Law is based on definition and grammar. The actual rules of their law are found in the uncommon words and peculiar grammar they have adopted. The way they legally define words is the foundation of their strategy to keep the average man ignorant of their law. Words used in purely legal matters have different meanings than the same words used in normal and ordinary usage. Thus, it is imperative that you understand their language legalese.
A verbis legis non est recidendum.
From the words of the law, there must be no departure.
Sensus verborum est anima legis.
The meaning of words is the spirit of the law.
Ad proximum antecedens fiat relatio, nisi impediatur sententia.
The antecedent bears relation to what follows next, unless it destroys the meaning of the sentence.
Copulatio verborum indicat acceptionem in eodem sensu.
Coupling words together shows that they ought to be understood in the same sense.
Mala grammatica non vitiat chartam, sed in expositione instrumentorum mala grammatica quod fieri possit evitanda est.
Bad grammar does not vitiate a deed, but in the construction of instruments, bad grammar, as far as it can be done, is to be avoided.
Generalia verba sunt generaliter intelligenda.
General words are understood in a general sense.
Maledicta est expositio quare corrumpit textum.
It is a bad construction which corrupts the text.
Non est certandum de regulis iuris.
There is no disputing about rules of law. Man's commercial law is not only precise, it's to the letter. The most common trick is their attachments of uncommon meanings and definitions to words used in their legal documents. We cannot stress enough the need for you to search out the definition of every single word in at least 2 or more law and English language dictionaries. We recommend that you purchase or borrow one or more of the generally accepted law dictionaries such as Bouvier's, Ballantyne's, or Black's. Most county law libraries have at least one of these in their reference sections. It's better to have access to the oldest as well as the most recent editions. The operation of modern law. All laws operate in separate and distinct domains and must be approached and dealt with inside of their own unique vacuum. Commercial law has no place in ecclesiastical, church law, or canon law, and vice versa. For example, you cannot apply biblical law or ancient Hebrew law to man's modern commercial law of legalities. In this day and age, they exist in separate domains and venues. They cannot be mixed. There was a time when the law of the land was based upon God's law, but that is not true today. What was once the common law based on biblical and spiritual laws is now the common law merchant based on legalities that appear as law but are operated within and under the color of law. Normally, if it looks like law, operates as law, and appears to be law, then it must be law. In commercial law, the rules of law and the process of law appear to the untrained mind as being normal law, but they are not. Commercial law operates within the appearance of law, but it is nothing more than the legal form of law, not law itself. Don't forget that the entire world operates within the commercial process and rules outlined within the UCC. To use the materials presented further on in this report, one need not any special intelligence or a master's degree. The spirit of fear has told Moors they cannot understand nor operate within the realm of commercial law without failure, but this is a lie. Up to this time in history, and especially during the past 100 years in America, the true church has done little or nothing to stop the steady elimination of the freedom and liberty given to us by the Lord God. This has come about by our ignorance of man's commercial law, laziness to test all things to see if they are of the Spirit of God, and blind trust in those to whom we have given worldly authority over us. The real tragedy is what we have not done. The church has not rebutted what claim has been made against us. However, the program you're now learning can lawfully and legally change your commercial status as a servant of the merchant to that of a sovereign within their system. A Moor can have control of his life within and over the commercial law, as you will soon begin to understand. After endless weeks of research, we have come to the conclusion that this program is essential for securing your freedom from legal commercial slavery. At first, it was difficult for us to accept the fact that an answer was available within the legal domain of commercial law. But we feel the Spirit of Allah/God has shown us clearly and precisely that a door was left open waiting to be discovered by us as we were diligent to seek the answers. As Moors, the worst thing we could do right now, considering the state of affairs of the world, is sit back and do nothing.
Multiudo errantium non parit errori patrocinium.
The multitude of those who err is no excuse for error. Your next step is to completely understand the material presented to you so far. You must become clear as to the foundation of commercial law. If you don't fully comprehend any word or sentence up to this point, go back and educate yourself word by word with the aid of law dictionaries. Check out what you have learned with the UCC so you can see how it applies and what it really means. Never let the spirit of fear stop you. Do not rush to the last part of this report and look for a silver bullet because it doesn't exist. In order to use this process successfully, it's mandatory that you understand how and why the process works. This is a foreign law and language to you, so you must learn to walk before you run. Part 3, Artificial Entities and the Persona, will further explain how the commercial law has made a claim against you. Part 3, Artificial Entities and the Persona. Real versus imaginary. From the beginning, man was created in two domains. When these two realms are combined, a man is complete. First, man is composed and born in a physical form. This part of man can be called the biological man or the physical realm of life. Simply said, this is your flesh, blood, muscle, and bones. Secondly, man is born of the Spirit of God with a soul. It is the spirit and soul that brings life to the physical. This is also the realm of man where he develops his mind, ideas, ego, personality, and concepts. Where the first part is physical, the second is not, including aspect thought. Neither part can exist without the other, but the aspect thoughts of man could never exist without the physical domain existing first. One cannot have thoughts without a physical brain. Think of it as a relationship between the stars, aspect thought, and the sun, physical. The mind and thoughts of man can only exist with the physical body in the same way the stars revolve around the sun. As the physical grows and develops, so does abstract thought. You could say that abstract thoughts are based on physical reality, but completed by imagination. An example of this is the difference between a real or imaginary friend. Children fully understand the physical being and know that a real person is flesh and blood, as they are. Their physical friends can be touched, seen, and heard, but some children have imaginary friends who are nothing more than aspects of thought without physical bodies. They can't be touched or seen physically, but in the thought process, they exist. This could also be described as the difference between tangible and intangible, material and immaterial, reality and concept. Artificial entities. In the process of thought, man also has the ability to convert many abstracts into a single concept. For example, even though all Moorish and Christian men and women are individual parts of the body of Yeshua the Christ, we are all collectively called the temple or church. There are more than 10 players on a football squad, but collectively they become one singular team. In this manner of thought, when separate beings form together as one, they collectively become a singular. Just what is a corporation? It is a group of beings who have formed together under statute law to become as if they were only one being. Physically, this is impossible, but conceptually within the mind, this is the same as a child's imaginary friend. The same applies to a limited partnership, LP or LTD, or a limited liability corporation, LLC. In reality, a corporation, trust, limited partnership, and government are mere imaginary beings. The legal term for this is artificial entity, a fictitious being. The persona mask. What becomes a danger is when man begins to accept that which is not physically real as if it is real. When a single artificial being is treated as a reality, the legal result is a fictitious entity. The modern and commercial laws call this fictitious being a person. And the common man's understanding, a person is real and can be touched, such as the person at the grocery store who works as a cashier. However, in modern law, a person can be real or artificial. This is an example of why we keep stressing the fact that you must look up each and every word in a law dictionary in order to understand the definitions as they apply to commercial law and all modern law. Legally, a person can be a real physical being or a corporation. Person. An entity with legal rights in existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court either by themselves or by lawyer, and, generally, other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity, such as a court finding of mental incapacity. Many laws give certain powers to persons, which, in almost all instances, include business organizations that have been formally registered, such as partnerships, corporations, or associations. Duhame's Law Dictionary. Legal person. A body of persons or an entity, as a corporation, considered as having many of the rights and responsibilities of a natural person, and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Artificial person, a legal person. Webster's. Another name for a fictitious entity is persona. The word persona is a Latin word signifying a mask used by actors on the stage. While the real being exists physically, the persona is an artificial face or mask and is not a reality. It covers the real being with an artificial being, the same as a mask covers your face. Since this artificial persona is not you, the Moorish man or woman born of the spirit of the Allah, God, we must be able to prove which is our real being and which is our persona. The simplest way to tell the difference legally is via the use of all capital letters, which signifies the persona. How do you spell your Christian birth or baptism name? As Amor Salam Bey or Amor Salam Bey? How were you born? As an artificial person or as a Moorish being? While some may say that capitalization of a name makes no difference, in all languages in this world it is not grammatically correct. According to the rules of English grammar, it signifies nothing. Your physical and real being is named John Joseph Smith. Your legal and artificial persona is named Amor Salam Bey. It does make a difference, legally. How is your name spelled on your driver's license or credit card? In all capitals or grammatically? Your nom de guerre. Man inherently knows he has no right or dominion over other men, but he has invented ways to seek such gain by creating the persona which, when applied to commercial law and martial law, becomes a nom de guerre. This is literally a war name to separate the Christian from the fictional persona. See the California Style Manual, published by the California Supreme Court, 1986, Section 196, page 13, Style of Main Title, to an action. How a name is spelled brings to distinction the ultimate conflict of the real man, the Moorish man, and the fictitious imitation of the Moorish man that is a persona. Names are deliberately spelled on all birth certificates, court dockets, state licenses, etc., with all capital letters. The modern law uses the nom de guerre in all instances of spelling a legal name. Being bound under treaty of international law and the lex mercatoria, commercial law, today's purported courts and all government agencies are prohibited from dealing with real people and are required to deal only with fictional persona, artificial persons, by styling all parties with a nom de guerre. A corporation is also a fictional persona, and this includes state-incorporated Christian churches. Any party who agrees to appear before the system must do so by a persona or nom de guerre spelled in all capital letters or with a middle initial. Amor spells his name according to the rules of English grammar, using both capital and lowercase letters, such as Amor Salam Bey, as opposed to the nom de guerre Amor Bey or Amor S. Bey in all caps. A corporation or any other artificial legal entity is spelled in the same manner, such as State of New Jersey in all caps, U.S. in all caps, United States in all caps, or Acme Incorporation in all caps. Strawman equal real party and interest equal persona. It is via the persona and nom de guerre that the UCC has attached itself to you. In part one, we discussed the straw man or real person in interest, the RPII, to all contracts. The straw man was the means by which the creditor, real party of interest, collected his claims. The agencies of essentially all the world's governments coordinating with the real parties of interest who own the law, all money, and all commerce created your straw man shortly after your physical birth. Thus, the creation of a legal commercial birth certificate to take the place of your lawful record of birth. This is the means by which the commercial law, UCC, operates. Their legal system bases everything on the simple presumption that you have contractually agreed that your straw man, the real party in interest or persona, is their exclusive chattel property. The legal reasoning behind all of this is quite simple. Commercial and governmental law can claim only against fictitious entities or artificial persons, a persona, and the commercial documents that have created them, such as corporations, trusts, certificates of title, birth certificates, marriage certificates, etc. Such artificial persons include your all-capitalized lettered name, your straw man, which is also called your corporate soul or the incorporation of yourself. Your persona is symbolic evidence of your self-incorporation. Since they created and presumed ownership of your straw man, they can tax, regulate, and destroy their property as they see fit. Your physical biological person has been legally united with your fictitious person, who is also your straw man. Your straw man, real party in interest, includes your physical being, now legally united as one with the persona, as well as your words, concepts, thoughts, and ideas with which you interact with other people. Legally, there is no difference between the two unless a rebuttal or objection by the real being has been made against their presumption of contract over the straw man. When you view the definition of a straw man, it's very clear why the system has placed your persona or artificial mask as the real party in interest. Straw man, an intermediary for a transaction, as a conveyance of real property. Merriam-Webster's Dictionary of Law, 1996. Part 4. How legalism took over the law will expose further the use of legalism in place of law. How legalism took over the law. In common law, the previous law of the land, it was very clear that a Moor was sovereign. This meant that he possessed all rights to control his own property. Most state constitutions still have a clause basically stating that unless the statutes or prevailing law prohibit otherwise or supersede the English common law, it is still in force and effect. Obviously, all common law in the U.S. has been squashed by commercial law, which is why there are no more common law rights, including property rights. Commercial law is legalism, while common law is lawful. Legalism has the form and characteristics of law, but is not law in itself. It is nothing more than the color of law. Forget about common law for right now. It doesn't apply to our goals and purpose in this instance. The purpose of this project report is to reveal the legalities of commercial law, not the real law itself. Force your mind to think like a lawyer by setting aside what makes common sense or what rights you have. Rights and God have nothing to do with the legalities of commercial law. What has happened as a result of the legalities of commercial law is easy to understand. Number 1, the real physical being has been united with his persona or straw man by presumed contract. Number 2, the straw man has become the real party in interest to all property of the real being. Number 3, the absolute sovereign over the straw man is the real party of interest. Number 4, the real party of interest applies legal rules and process of commerce to all his claims. Number 5, if the real physical being does not object by commercial rules and procedure, it is presumed he agrees to the presumed contract relationship. The world power brokers defined in Part 1 are the absolute sovereigns over you in their status as the real party of interest. They may tax you as they please, force you to obtain licenses, permissions for a fee to do ordinary tasks, impose fines upon you, regulate your movement and speech, demand you perform labor for them, imprison you, or whatever they wish. An easy way to look at the commercial law real party of interest is that of a king with unlimited rule and power. Thus, he is your sovereign authority. Remember, in commercial law, there's no distinction between you and your persona, as both are united into one and the same. In this legal status, you have no capacity or means to enforce any rights. The legal term for this is that you have no standing in law. Why? Because a servant cannot sue his master, nor can a slave sue his king. Who owns your rights? The state does, since all commercial government is owned by the world power brokers. You're nothing more than collateral for payment of the world power broker liens against the state by reason of bankruptcy. Legally, you are considered a slave or indentured servant to the various federal, state, and local world power broker governments via your birth certificate. The reason you are issued a certificate is that the actual title of birth is held by them. This is compounded further when you voluntarily obtain a driver's license or a social security identification number. Even your personal and private life is owned by them through your state-issued marriage certificate. Once again, your title to marriage is held by them. You have no rights in birth, marriage, or even death. They hold the rights to all titles. The key is to find a way to regain legal ownership of your straw man, and this sums up the purpose of this entire project report. When the physical being secures legal ownership of his persona, the real man is reunited with his rights, including his ownership titles. As long as the state retains ownership of your persona, they own all of your inherent rights. In commercial law, when you legally own the persona, you own the titles to all your rights. It's not that you have ever lost your rights, it's the fact that through your persona, the system has secured your rights and titles to rights as collateral. Once you legally break the bond between the real being and the artificial persona, you become the ultimate sovereign of your legal status. No artificial entity can make a claim against you or your property once you have broken this legal tie. When you become owner of your straw man, you will legally become the owner of all claims made against him. If this confuses you, then you must look at this according to legalism and nothing more. Right now, they own your straw man. The only way for you to regain ownership of your persona is through use of their legalities. This must be done according to their laws and in no other way. You can quote all the common law or Bible passages you want at them, but unless you speak their language, they are not required to recognize you. In fact, they have the power to punish you if you attack them with the wrong words from the wrong jurisdictional domain. However, there is good news. Once you legally obtain ownership of your persona and its nom de gore, you become the absolute sovereign over the artificial name and artificial entity that has bound you, the real man, to their commercial law. At that point, and only then, will you have the legal power to stop all their claims against you. You will legally place a wall between you, your being and persona, and the system. This stops them in all their claims from the beginning ab initio. How did we get into this mess? Legally, it is their contractual ownership by simple presumption of your persona that is the foundation of your servitude to the system. Once you legally rebut and remove this presumption of contract ownership between the real you and your straw man, all claims against you are abolished as if they never existed. This will change your legal status to that of a sovereign and free man. The reason they have presumed their contract ownership is due to the fact that you have stood silent and not legally challenged their claim. Breaking their presumed contract goes much further than you might ever imagine. Once broken, you regain your birthright and legal capacity as that of a sovereign. This term, in a purely legal sense, denotes the absolute ability, power, qualification, or competency of persons, either real or artificial, for the performance of claims or acts as defined and fixed by law. Such absolute power as the capacity to devise, to bequeath, to grant, or to convey land and property of all kind is bestowed upon he who holds legal capacity. He may take and hold property as a sovereign. That was the former law of the land. Now you can see why the system has had control over all your property. In the same context, once you have obtained legal capacity, you can begin to understand how you will regain control and authority of what is yours by right and by modern law. Our current problem is that we have voluntarily contracted with and agreed to their system of commercial law by simply remaining silent, legal default, and not making claim to our rights. The legal rules of commercial law enforce themselves. There is no court hearing to determine if the rules are correct. Their law is self-regulating and self-supporting. Once set into motion, their laws automatically come into effect, provided their legal process has been followed. By adhering to their legal process and rules, you can break their contract according to their own rules. You are now ready to absorb Part 5, Commercial Contracts and the UCC. Part 5, Commercial Contracts and the UCC. Much of what you will read in this longest part of our project report will join together and reiterate the principles you have learned so far. Putting all the pieces together is essential for a complete understanding. Once again, We caution each reader to fully understand the definitions, maxims of law, and legal principles already presented before continuing. If in doubt, go back and read it all again right from the beginning. Current commercial status. Every government, be it federal, state, or county, is an artificial entity. Because of this, governments can only legally interact with their own like and kind, other artificial persons. This is why governments address your persona and not the real you. The all-capitalized name addressed on an envelope or a court docket to the real you proves this fact. Governments, the system, cannot interact with anything outside their legal domain, such as a Moor by name who stands in Allah/God's domain. Artificial persons like governments, their agencies, their law enforcement branches, or their courts have no reality, are not physical or biological, have no substance, and cannot go outside their domain into a realm that is actual, physical, or real. Governments are corporations created by commercial law and not by Allah/God. When the persona violates a rule or a statute, such as a traffic infraction, the real you is expected to appear at an arraignment and admit to the straw man's name. That is why at the beginning of an arraignment or any court proceeding, your name is called and you are required to answer. The name they are calling is your persona, but like sheep gone to slaughter, we answer to this request even though we are not whom they are calling. If you were to answer in your Moorish appellation, spelling it out in upper and lowercase letters, then you have broken the contract tie they attempt to establish between the real being and the artificial person. They can only deal with the artificial, not the Moor. Governments cannot legally, as set forth by their own laws, involve themselves with anything but other artificial entities, persona, and the commercial law contracts entered into between them. This is why it is a necessity by their legal rules and process to use capital letters in all names, including their own. They must address the entity, not the real Christian man or woman. Governments can only act against the artificial persons that they have created. It's that simple. The real you, a Moorish man or woman, can have a claim made against him by a government based on the presumption that you have voluntarily, knowingly, and intentionally contracted to be identified with and by your persona. The persona is not really you, but rather an artificial person owned by the government to which you have united with. The world power brokers who own, fully know the workings of, and utilize their laws to pilfer, conquer, subjugate, and lay claim to all those on the earth invoke a very simple and basic principle of law to accomplish this. An undisputed affidavit of claim stands as truth in commerce. See background in Part 1. It makes no difference if their claim is unlawful, immoral, or illegal. Unless you, not someone else, speak out against their claim with an affidavit of rebuttal, their affidavit of claim against you is considered undeniable truth in all law and commerce. No ABA bar attorney can speak for you. You must speak for yourself. By not rebutting and remaining silent, you have legally defaulted and they can claim all they want against you. Any Moor who does not speak up for his inherent rights has none. The worst thing a Moor can do is to remain silent. The next worst thing he can do is agree to the implied and presumed contract. This is done through the real man's acceptance of benefits and privileges granted by the sovereign. The legal terminology of this is ratification by act of consent. When the real man accepts a driver's license in the name of his persona, all capital letters, he has ratified the presumed contract between the real person, a physical being, and the real party of interest, who uses the state as his real party in interest to collect his claims via your straw man. The same applies to acceptance of unemployment insurance, Social Security benefits, welfare, food stamps, ad nauseum. When you contract for benefits, privileges, licenses, permits, etc., you are bound by commercial contract to the obligations that are attached to them.
Qui sentite commodum sentire debetetonus.
He who enjoys the benefit ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its condition or conditions. Source: Bouvier's Maxims of Law, 1856. Commercial contract key elements. All commercial law and interaction between men is contract. See introduction. From this implied and presumed contract with your persona, every action by government or their agents is founded. In accordance with the UCC, restatement at subsection 110, the parties may now enter into a binding agreement without signing a formal written document. What you must now learn is the legalities of this presumed contract and how to rebut it. The birth certificate. First, you must know exactly what is considered to be the key element within the presumed contract that holds title and ownership to a real man's labors, rights, intellect, and property through his persona. This foundational element is legally called an instrument, but you know it as your birth certificate. Since the early 1960s, birth certificates were issued by the government to persona with all capital lettered names. This is not a lawful record of your physical birth, but something totally different. A birth certificate is the government's commercial instrument to their legal title of ownership or deed to your straw man. Don't forget that the presumption in contract is that the real you and your persona are one and the same. This commercial record or commercial instrument, birth certificate, is a legal commercial receipt. It's no different than any other commercial bill of lading or warehouse receipt. Delivery of the commercial goods was made to the government at your local hospital. For clarity, view a birth certificate as a commercial document of title. While this document of title is not the title itself, it is parallel to a commercial certificate of title or certificate of birth. UCC 1-201 definitions. Subsection 15. Document of title includes bill of lading, dock warrant, dock receipt, warehouse receipt, or order for delivery of goods, and also any other document which in the regular course of business or financing is treated as adequately evidencing that the person in possession of it is entitled to receive, hold, and dispose of the documents and the goods it covers. Bill of lading means a document evidencing the receipt of goods for shipment issued by a person engaged in the business of transporting or forwarding goods. A hospital, for example, and includes an air bill. The U.S. corporate federal government is bankrupt and holds no constitutionally mandated silver or gold, coin and bullion, to back up or pay their debts. All privately held and federally held gold coins and bullion in America was seized by executive order on April 5, 1933, and paid to the creditor, the private Federal Reserve Bank Corporation, under the terms of bankruptcy. Then, in 1964, coins with no silver content were issued and the constitutional silver coins were recalled and seized. Further evidence of this was the shortage of industrial silver and bullion from the mid-1960s through the mid-1970s. The small inventories of silver available during this period was astronomically expensive. We called the copper edge coins LBJ funny money, at the time not understanding or knowing that all the silver was being turned over to the creditor, the privately owned Federal Reserve Bank. The only asset the federal U.S. government has in order to pay their corporate debt is the people themselves. So they commercially pledge birthright Americans as collateral for credit loans to pay daily operational costs. The technical way this is done is astoundingly simple, but relatively unknown. When a child is born within the corporate United States, a record of live birth form, a commercial bill of lading, or similar, is issued by the hospital. The father and mother sign this hospital form, a receipt for goods, as the parents, manufacturer, and title holders of the goods, child. The transfer of the property rights, the child's rights, to the state is accepted by the signature of their government agent, a state licensed physician. The parents have unknowingly pledged their child's future and labors to the government and signed a presumed contract. This converts the legal status of their child to that of chattel property and permanently indentured servitude. See preface part 1. The state becomes the de facto holder of the rights to the child, the collateral. Next, the hospital sends the record of live birth to the State Bureau of Vital Records, sometimes called the Department of Health and Rehabilitative Services, HRS, in some states. Each state is required to supply the federal government with birth, death, and health statistics. The state agency that receives the record of live birth title keeps it and then issues a birth certificate, BC. The BC is a commercial instrument, document, evidencing that the state is holding the title, ownership to the child. Holding the title is not the same as having possession of the property, so the state is the holder of the instrument, but not the holder in due course. This is all based on the presumed acceptance of the contract, record of live birth, between the manufacturer, parents, and the purchaser, state. The parents are not aware of this assumed contract because it was never revealed to them, nor was full disclosure made in good faith, so they don't object to what they don't know. The current holder of your commercial birth document, receipt, is able to capitalize on it because of your failure to instruct the holder to do otherwise, due to your silence and lack of legal action. Certificate, noun, Middle English certificat, from Middle French, from Medieval Latin, certificatum, from Late Latin, neuter or certificatus, past participle of certificare, to certify, 15th century. Sense 3, a document evidencing ownership or debt, Merriam-Webster Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce through their agency, the U.S. Census Bureau, who is responsible to collect vital statistics from all the states. The word registered in commercial law does not mean that your name was merely noted in a registry or a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the child's persona named on it has become a surety or guarantor as collateral for a commercial loan. Registered, security, or bond, Merriam-Webster Dictionary of Law, 1996. Security, 1A, something as a mortgage or collateral that is provided to make certain the fulfillment of an obligation. Example, used in property as security for a loan. 1B, surety. Sense 2, evidence of indebtedness, ownership, or the right to ownership. Bond. Sense 1A, a usually formal written agreement by which a person undertakes to perform a certain act, as fulfill the obligations of a contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person or surety. 1B, one who acts as a surety. Sense 2, an interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. Surety, the person who has pledged him or herself to pay back money or perform a certain action if the principal to a contract fails, as collateral and as part of the original contract. Duhame's Law Dictionary. Sense 1, a formal engagement as a pledge given for the fulfillment of an undertaking. Sense 2, one who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor, and the two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor, a person who pledges collateral for the contract of another, but separately, as part of an independently contract with the obligee of the original contract. Duhame's Law Dictionary. It is not difficult to see that a birth certificate is a document evidencing debt the moment it is issued. This is how it works. Once each state is registered by commercial bulk transfer the birth certificates with the U.S. Department of Commerce, the U.S. Department of Treasury then issues Treasury securities in the form of Treasury bonds, notes, and bills using the birth certificate as sureties or guarantors for the purported securities. This means that the bankrupt corporate U.S. can guarantee to the purchasers of their securities the lifetime labor of all Americans as collateral for payment. Isn't it nice to know that when you were born, within days you became the collateral for corporate U.S. debt loans through the assumed contract your parents thought was nothing more than a record of live birth? But wait, the chain of events gets even more interesting. Who purchases these Treasury securities? Nearly all are purchased by commercial institutions and brokerage firms on behalf of their individual clients. These purchases are called commercial book entry transactions, whereby the individual purchaser never receives a paper stock certificate. Follow very closely and see if you can notice the monopoly and identity of the world power brokers unfolding here. Keywords are underlined. Number 1. The commercial book entry system is operated exclusively by the privately owned Federal Reserve System, formerly the Federal Reserve Bank, as fiscal agents of the U.S. Treasury Department. Number 2. All these securities are recorded in the commercial book entry system as book entry issues held for the account of the depository institution. Number 3. The exclusive depository institution is the Depository Trust Company, DTC, a privately owned trust company bank who maintains records identifying the individual beneficial owners of securities that the DTC holder in its account in the commercial book entry system. Number 4. The Depository Trust Company is an operating unit of, owned by, the Federal Reserve System. Number 5. The Depository Trust Company transfers all the securities to their own private holding company, Seed & Company. Number 6. Seed & Company is the holder of nearly $20 trillion of stocks and bonds. Number 7. The Federal Reserve System uses the Treasury securities it holds as collateral to print and issue Federal Reserve notes, which are further debt obligations. What starts out as a record of birth becomes a monopoly of collateral slavery in the hands of the world power brokers, also known as the privately owned Federal Reserve System. The ultimate real party of interest to your persona or straw man is seed and company, since you are the collateral and surety for the Treasury securities that are physically held by them in their name. It's worthy to note that as you walk up to the DTC skyscraper at 55 Water Street in New York City, the sign in the front says, "The Tower of Power." When you reclaim the title deed and ownership of the real you through your birth certificate by accepting it back for its commercial value, you regain your sovereignty, freedom, and liberty. The Wizard of Oz, also known as the World Power Brokers, who have alleged to be the real party of interest, and all their agents will then be legally powerless. Legally, only you can give back yourself your own inherent sovereignty. Once again, the foundational truth being that all law is contract, the World Power Brokers, WPB, have successfully made their claims by making us subject via contract to their sovereignty and ownership. The same rules that have made us servants and slaves to the World Power Brokers can also set us free from their legal claims. The key is going to the source and making it apply to our current legal status dilemma. There are many maxims, truths, or proverbs of law that state this.
Niltam naturale est, quem eo genere quid que dissolvere, quo colligatum est.
It is very natural that an obligation should not be dissolved but by the same principle which were observed in contracting it.
Qui evertit causam, evertit causatum futurum.
He overthrows the cause, overthrows its future effect.
Sublata causa tollitur effectus.
Remove the cause and the effect will cease.
Cuiusque rei potissima pars principium est.
The principal part of everything is in the beginning. The World Power Brokers follow the same legal rules to set up their system. We must follow the same legal rules to escape their system. Knowing how they set this up is an element behind the reasoning for its existence. Part 5 through 7. Commercial contracts in the UCC continue. When the original 13 sovereign nations of North America declared and received independence more than 200 years ago, the World Power Brokers, comprised of kings, bankers, and merchants, lost a wealth of future commerce and profits from their previous colony franchises and letters patent. Since then, the World Power Brokers have continually strived and schemed to regain their control and ownership of the real American people. They have been the instrumental force behind the conversion of free American states into the corporate and commercial United States. They have founded their takeover on outright deceit and presumptions without a single outcry from the American people. However, these presumptions and implied contracts can be rebutted according to the legalities they themselves have set into place. It's kind of like the old saying, what's good for the goose is good for the gander. In order to get in the front door, they had to leave the back door open for their own protection in case they needed to escape. But who's to say their servants can't use the same back door to escape? The law says we can, and the door has been left wide open. They simply cannot abolish the legal means of our escape unless they abolish the legal means that put them in power and control. Their entire plan backfires in their faces when the contract presumptions are rebutted by the same legal rules and procedures they have set into place. The only reason they have succeeded to this point is that the American people now live in a false complacency, happy and satisfied with their debt contracts for houses, cars, boats, airplanes, and much more. But many of us know that this lifestyle is soon to change into a more realistic picture of the actual and physical servitude and slavery. The debts must be paid. Not only is the U.S. government broke, but so are the American people. Had Christian Americans followed the principles and laws written in the Bible, as did the early Americans, they would never be in this position. There is no doubt that the World Power Brokers have been dangling the bait of debt/credit as a means to entice the common man to obtain material wealth without having to pay up front for it. Has any average American ever taken the time to think what would happen if the loans they now have were called in for payment? Where will you house your family? How will you drive to your job? How will you purchase your food? Can't happen, commented an AB lawyer reviewing this material. When we pointed out that any declared emergency by the bankrupt federal government voids the payment terms of all contracts and legally all debt becomes due and payable at will, he thought about it again and had to agree with us. Our premise for argument was that Roosevelt confiscated all the gold in 1933 just for that purpose, as well as the Uniform Commercial Code itself, which states, UCC 1-208, option to accelerated will, a term providing that one party or the party successor in interest may accelerate payment or performance or require collateral or additional collateral at will, or when she or he deems herself or himself insecure, or in words of similar import, shall be construed to mean that she or he shall have power to do so only if she or he in good faith believes that the prospect of payment or performance is impaired. The burden of establishing lack of good faith is on the party against whom the power has been exercised. Method of rebuttal. In 1998, the federal and corporate United States joined the United Nations Convention on Contracts for the International Sale of Goods, which now governs contracts within its scope. According to international and universal uniform contract law, such as the UCC, a contract can only be valid if it follows all the rules and process of law that created it. One of the main elements or rules of contract states that all parties must understand the scope, nature, terms, and conditions of the contract. Another main element states that all parties must consent to the contract. If it is not agreed to and there is no mutual consent, then there is no contract. Any purported commercial contract that fails to be entered into by mutual good faith, with full disclosure of the terms and conditions to both parties and consent by all parties, is void ab initio, from the beginning. Whenever the elements of good faith, disclosure, and/or consent are missing, any contract can automatically be ruled null and void if the deceived or defrauded party enforces the rule of law. Once again, silence is default. If you say nothing, you have defaulted. UCC 1-203, obligation of good faith. Every contract or duty within the code imposes an obligation of good faith in its performance or enforcement. Were you aware of the implied and presumed contract between you and the real party of interest, the owners of the Federal Reserve System? In all law and truth, it doesn't exist, does it? UCC 1-201 definitions, subsection 31. Presumption or presumed means that the trier of fact must find the existence of the fact presumed unless and until evidence is introduced which would support a finding of its non-existence. Were all the terms and conditions disclosed to you at birth or any time since then? Of course not. Legally, once you rebut the presumption by affidavit for failure to disclose the terms and conditions or obtain mutual consent, the contract automatically becomes null and void. Such a contract as this, which is unlawfully bound the average American to it, is considered fraud or misrepresentation. For example, UCC 1-103, Supplementary General Principles of Law Applicable. Unless displaced by the particular provisions of this code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause, shall supplement its provisions. As you can see now, the major flaw in all artificial government and their laws is the absence of a genuine and legal agreement between the parties due to a failure to fully disclose, have a meeting of the minds, and lack mutual good faith. In their presumption that you have agreed to a bona fide contract with the government, you were never informed of the full terms and conditions of the purported contract. The reason this situation could exist in the first place is due to the fact that the American people have fooled themselves, lied to themselves, and failed to communicate among themselves. They have put aside their holy Bibles and replaced the true law of God with the laws of men. The world of man's laws and government was brought about by the very people who are now servants to the system. Since Lincoln's War, Christian Americans have lived in fear of speaking out against wrongs they see taking place. According to the universal principles and foundations of contract law, see background part 1, in the absence of a genuine agreement, no contract exists. What does exist is nothing more than a presumption of contract based on the deceived party, you, having foolishly trusted in the government. Although fraud is unlawful, it is not illegal in artificial state rulership systems. Keep in mind once again that all governments are structurally fraudulent due to their origins of their artificial conception. Based on this premise of evidence, it is obvious fact that fraud must be legal, as governments are able to judge themselves as legal in the first place. In other words, the existence of a government is a legality of fraud ab initio. Holder in due course. In commercial law, the ultimate owner of any document of title is known as the holder in due course, HDC. He is the only one who possesses a valid claim to title whereby the goods or property are deliverable to him. By comparison, a technical holder may legally possess a negotiable instrument, but he lacks the ultimate claim of title held by the holder in due course and is nothing more than a receiver and collector of payments. The holder in due course receives the delivery of the property. The holder merely receives payment for the property. UCC 1-201 Definitions, subsection 20. Holder, with respect to a negotiable instrument, means the person in possession if the instrument is payable to bearer, or, in the case of an instrument payable to an identified person, if the identified person is in possession. Holder, with respect to a document of title, means the person in possession if the goods are deliverable to bearer or to the order of the person in possession. UCC 3-302, Holder in due course. Subject to subsection C and section 3-106D, holder in due course means the holder of an instrument if, number one, the instrument when issued or negotiated to the holder does not bear such apparent evidence of forgery or alteration or is not otherwise so irregular or incomplete as to call into question its authenticity. And number two, the holder took the instrument, number one, for value, number two, in good faith, number three, without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to payment or another instrument issued as a part of the same series. Number four, without notice that the instrument contains an unauthorized signature or has been altered. Number five, without notice of any claim to the instrument described in section 3-306. And number six, without notice that any party has a defense or claim in recoupment described in section 3305A. As stated earlier, your birth certificate is simply a warehouse receipt. Birth certificates are bundled together and transferred or purchased in bulk sales under one or more of the provisions found in UCC 6-104 through 108. However, possession of your birth certificate was not taken by the government in good faith, and the holder, government, cannot enforce the instrument free of all claims and personal defenses. This means that whoever or whatever artificial entity is now acting as the purported owner of your birth certificate can, in legal reality, only be a technical holder of the negotiable instrument and can never be the actual holder in due course. Only you can be the HDC or holder in due course. The holder in due course is the most powerful position in any exchange of property or goods in commercial law. The allodial key to understanding this lies in whether you are or are not the holder in due course of your document of title of birth, the negotiable instrument to your legal existence. Once you see that you are the legal holder in due course to your own title of rights, your whole worldly life will change dramatically. You are then once again a sovereign with respect to anything of which you are the holder in due course. This will make you the holder in due course of yourself, both the real biological person and the artificial persona. It will place you as the ultimate owner of all your earthly affairs and everything else concerning ownership of your legal life. When you really think about it, this is the legal means by which your physical being and your spiritual being can join together in true freedom and liberty. The secret to becoming the holder in due course is known as acceptance for value. Your birth certificate, document of title, is currently held by unknown parties who can never be the holder in due course of it. Only you and you alone can become the holder in due course. When your offer of purchase is made, title passes upon acceptance of the offer. The offer, your UCC-1, is accepted by the previous holder, the government, when they record it in the state records for a fee payment, value. The acceptance for value is made by the government in accordance with two rules of law. One, the fee paid for the recording of the instrument, and two, since it is recorded without objection, it is also accepted by their own conduct, both implied and direct. All there remains to do at this point is to give or show affidavit evidence of the exchange, a copy of your recorded UCC-1 financing statement with the state-accepted seal and certification. Acceptance and offer are the two mandatory elements to any legal contract in commercial law. Acceptance, or acceptance for value, for the purpose of commercial law, is acquiescence. Look carefully at these definitions written by Canadian lawyer Lloyd Duhame from Duhame's Law Dictionary. Acceptance. A contract is a legally binding agreement between two or more parties which starts with an offer from one person, but which does not become a contract until the other party signifies an unequivocal willingness to accept the terms of that offer. The moment of acceptance is the moment from which a contract is said to exist, and not before. Acceptance need not always be direct and can be implied by conduct. Acquiescence. Action or inaction which binds a person legally even though it was not intended as such. For example, action which is not intended as direct acceptance of a contract will nevertheless stand as such as its implied recognition of the terms of the contract. If I display a basket of fruit at a marketplace and you come by, inspect an apple, and then bite into it, you have acquiesced to the contract of sale of that apple. Offer. An explicit proposal to contract which, if accepted, completes the contract and binds both the person that made the offer and the person accepting the offer to the terms of the contract. In this modern world, man's laws dictate that there are only two classes of people in any legal proceeding. You're either a creditor or a debtor. When your legal sovereignty is established, you become the sovereign creditor of your life and affairs. Every adverse party then becomes your debtor. However, if you do not establish your legal sovereignty, you do not own yourself, your own title, as a holder in due course. You have no legal capacity. You have no standing in law to assert your rights, and you will remain a permanent debtor as you are now. As debtor, you will always lose in every dispute or claim by the current system for failure to state a claim upon which relief can be granted. Reclaiming the legal ownership of your persona, straw man, acts as an equitable estoppel to any and all who come against you in commercial law. Equitable estoppel. An estoppel that prevents a person from adopting a new position that contradicts a previous position maintained by words, silence, or actions when allowing the new position to be adopted would unfairly harm another person who has relied on the previous position to his or her loss. Also called estoppel in pays. Source, Merriam-Webster's Dictionary of Law, 1996. If you do not reclaim your legal rights of title and ownership to your persona, which makes you the creditor and absolute sovereign ruler of your straw man, you will not be sovereign and you will lose every claim made against you. This is the reason why, if you think of hiring an ABA attorney to represent you in any legal proceeding against the system, you must demand up front that he make you the holder in due course of the action. Since he legally can't do this, then you will lose if he appears for or represents you. The best any barfly attorney can do is make a deal with the system creditor, which is a negotiated settlement of the money being claimed as damages. You must be the holder in due course to be able to ensure victory in all dealings with the government and the system. We conclude part 5 with some maxims for you to absorb.
Quod initio vitio sum est, non potest tractu temporis convalescere.
Time cannot render valid an act void in its origin.
Falsus in uno, falsus in omnibus.
False in one thing, false in everything.
Quae malas sunt in cota in principio vex pergantiur exiteu.
Things bad in the commencement seldom end well.
Quod ab initio non valet, in tractu temporis e non convalescere.
What is not good in the beginning cannot be rendered good by time. You are now ready for part 6, how to secure your freedom through use of a financing statement. Part 6, how to secure your freedom. The money game. As we stated earlier, the corporate entity known as the United States is bankrupt. Congress confirmed this bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause June 5, 1933, and House Joint Resolution 182, 73rd Congress, First Session, Public Law 73-10. Within this 1933 public law, it states in part, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy. In 1950, the corporate U.S. declared bankruptcy a second time, whereby the Secretary of Treasury was appointed as receiver of the Bankruptcy and Reorganization Plan No. 26, Title 5, United States Code, subsection 903, Public Law 94-564, Legislative History, page 5967. The issuance of paper as legal tender and circulating medium of exchange did not occur until 1862 during Lincoln's War. The Congress authorized the issuance of non-interest-bearing Treasury notes and declared the resulting bills of credit to be legal tender for all debts, public and private, with the exception of taxes on imports. The notes were deemed necessary to float the debt of the United States for the war effort. In reality, the corporate United States was already bankrupt. On June 3, 1864, Congress passed an act to provide a national currency secured by a pledge of United States bonds and to provide for the circulation and redemption thereof. Today, Federal Reserve notes are officially recognized as SDRs, or Special Drawing Rights, under the amended Bretton Woods Agreements Act, Public Law 94-564. See further legislative history, Senate Report Number 94-1148, October 1, 1976. As you can see, there is no lawful money in circulation today. What the average American thinks is money is nothing more than private commercial debt instruments made of paper, legal tender, evidencing the debt Americans are required to pay against the collective bankruptcy of the federal government. Real money is a tangible substance such as gold, silver, produced of the earth, or labor. Real money can never be debt. The original Mint Act was passed on Thursday, January 12, 1792. This act was drafted in pursuance with the Constitution for the United States of America, see Article 6, Clause 2, and provided for the minting of both gold and silver dollars under Section 9. This act met all the requirements of Article 1, Section 8, Clause 5 and 6, and Article 1, Section 10, Clause 1. The use of real money is a right of sovereigns, not slaves. Debt is created by a mere signature, authorizing notes of indebtedness. All money in circulation today is created for further borrowing against our federal bankruptcy. Only by borrowing against the government's bankruptcy can its servants and slaves have pieces of paper to spend like money, even though they are purely notes of indebtedness. Unless one is the holder in due course of one straw man, owning such paper debt notes or anything it buys is a liability, not an asset. The fact that people mistakenly consider Federal Reserve notes to be assets is a major cause of the problem we all face. Whenever a person accumulates private Federal Reserve notes, FRNs, he is accumulating more debt. The more Federal Reserve notes you have, the more commercial goods, property, and services you purchase with them, the more indebted you become. Since all purported money is created by the further borrowing against our federal government's bankruptcy by signature, every time you sign your name to any public document or contract or instrument involving Federal Reserve notes as a valuable consideration, you borrow against and increase your own debt. By increasing your borrowing and indebtedness, you're providing yourself with more debt instruments to spend. This is a telltale sign of a slave in permanent indentured servitude. He commits himself further and further in debt every time he borrows from his sovereign taskmaster. Again, since all modern paper money is created by borrowing against the collective bankruptcy of the corporate United States, it is mathematically impossible to ever pay off the debt. This is a never-ending nightmare that must end. And when it does, the common American will suffer greatly if he has not been diligent to break the bonds of servitude. The financing statement. The legal method to establish your sovereignty and freedom is through the use of a UCC-1 financing statement. By properly and legally recording the instrument, you become the holder in due course of your persona, thereby removing yourself from the current legal status as commercial chattel property. Some states have their own version of a UCC-1 financing statement and will only accept these versions. You should obtain one from your own state or local county clerk. Many state and local UCC filing officers have now adopted the National Financing Statement UCC-1 form developed by the International Association of Corporate Administrators, IACA, as a replacement for the various UCC-1 forms. A UCC-1 is a security agreement on property that is recorded to protect the lender's or secured party's investment. The basic information required is a secured party's name, the debtor's signature, secured party's address, debtor's mailing address, statement indicating types of or describing the items of collateral. General notes. An enforceable UCC-1 should be typed. Many states will reject handwritten forms. You must provide 2 originals if you expect the state to return a certified and recorded confirmed original back to you. Copies are not acceptable proof if you need to assert your sovereign rights to the system once you have filed this instrument. Any multiple addresses of the debtor should be included as additional locations in the spaces provided. You'll be charged an extra fee for each address. This is useful when you have lived in more than one state over the past 5 years. Make sure that you file the UCC-1 financing statement in the state where your birth certificate was issued, as well as in the state where you are now located. Although not required, we recommend you attach a copy of your birth certificate with your name spelled in all capital letters. Also remember that most states require that you renew or refile your UCC-1 every 5 years. Make sure it is always renewed and legally current. The fees for recording vary from state to state. If married, we also recommend both the husband and wife file a financing statement in the state where they were married. A wife should show both her married and maiden names as two separate debtors on the same financing statement. Her maiden name reflects the birth certificate persona, while her marriage surname, literally extra name, reflects her marriage certificate persona. Item C. Here's where you will want the state to mail your second certified and file marked original to. Use proper English with upper and lowercase letters as shown. If you no longer have your own commercial address and are located in general delivery, use the commercial box or address of a friend. Before the street address, make sure you put CO, signifying that this commercial address is not yours. Always place the federal postal code in brackets as shown. The rules of English grammar state that anything written within brackets signifies nothing. Item 1. This is for the debtor's information, your persona or straw man. Capitalize every letter since this legally designates the artificial entity or persona at his commercial address. Make sure you include the Social Security account number, SSAN, number and date of birth as shown in the example. If a particular state form does not provide a space for a date of birth, enter it in the form somewhere else, such as within the description of the collateral. Note, some states have rejected the UCC-1 form stating that both the debtor and secure party cannot be the same. Obviously, the clerks don't know English grammar. If this happens, only place a capitalized middle initial with a period after it, such as John J. Smith in the debtor information area. Item 3. This is for the secure party information, the real you. Remember, use upper and lowercase letters to signify your Christian or Moorish name according to the rules of English grammar. The real you does not have a commercial address. Show your location as general delivery at your local post office. A post office is not the same as a U.S. Postal Service. Never use a two-letter capitalized federal designation for your state. Prior to introduction of the zip code in the 1960s, states were abbreviated with 3 or more letters such as FLA, TEX, MICH, CONN, or MASS. If you don't remember, ask your parents or grandparents. Again, put your federal territory region code, zip code, in brackets. Item 4. Fill this in as shown or with very similar wording. If your state form has no provisions for a separate date of birth entry, put the date of birth here also. Item 6. Only the debtor, your persona, is required to sign. Use all capital letters for this signature. You may sign it in ink with all capitals or simply type in the persona with all caps, such as Bey, Amar Salam, or Amar Salam Bey, as you did in item 1. Make sure you mark after the signature debtor so it's very clear which party has signed or placed their seal on the instrument. Find out from your present state and your birth state how much the filing recording fee is. Send a money order with the 2 originals to the address they give. Please go to Part 7 for important information included in the summary. Part 7, Summary and Conclusions. The most powerful contract in the world is the UCC-1 financing statement. It is the ultimate modern-day legal foundation of commerce. It is the culmination and conclusion of a centuries-long refining process within commercial law. As all law is contract, this affidavit is the shining star of commercial legalism. All you are, all you do, and all you think is controlled by this legal affidavit. It quietly penetrates into your worldly life to control every aspect of your being. It has made you a servant and slave to the holder in due course of your life. It controls you and strips you of your God-inherent sovereignty. It has stripped away your freedom and liberty. It's your contract of complete servitude to the world power brokers. The financing statement currently held by the real party of interest and holder against your earthly life, your past and future labors, and all your property and goods is absolutely legal and binding. The security instrument of this presumed contract is your birth certificate. The world power broker bankers presently hold title to your persona and all that you are. You are the collateral for the debt held against your birth certificate. However, this contract was established by illegitimate and unlawful presumption, and it is an implied contract. Your failure to rebut, refute, challenge, or counterclaim against this presumption is the reason you have the current legal status of commercial chattel property. The world power broker bankers have conquered and enslaved the world only because of the ignorance, apathy, and legal default of each person they hold in servitude. You are the only real being on the face of the earth with the legal right, knowledge, power, or duty to speak for yourself. No one else can assert your rights. No lawyer, attorney, agent, or representative can redeem your rights for you. If you fail to assert your rights, you have legally bound yourself and agreed to be a slave subject to the wishes and whims of your taskmasters. This has happened to you simply because of your failure to challenge their presumption, regardless of how unlawful or immoral it may be. The state, artificial government entities can and will continue to act against your straw man or persona only if they continue to hold title due to your failure to redeem it. Failure to redeem or reclaim your title is a legal approval and consent to the presumption that the state is the de facto owner and holder of title to your straw man. De facto, in point of fact, actual, opposed to de jure, by right or rightful. Don't forget that your persona and your real physical being are united and bound together by the same implied contract and presumption. Any subject belonging to a sovereign has no standing in law to assert their rights. The system has the legal contractual right to treat you any way it chooses, regardless of how immoral or unfairly. When you file a UCC-1 financing statement against your straw man, it completely rebuts, repels, all presumptions of claim to your persona by anyone other than you. At the same time, your rebuttal affidavit itself becomes unrebuttable. The legal reasoning and law behind this is simple. Any future claims to a legal contract between you and attackers against your sovereignty is impossible because there never was a bona fide contract in the first place. This is because there was no mutual agreement made with full disclosure, a meeting of the minds, or good faith. You are, both legally and lawfully, the holder in due course of your own sovereignty. Whatever you choose to do or not do is always presumed to be your choice. If you fail to repel their implied contract that makes you subject to their system, they have on their side the legal rule of presumption that says you choose to act as you did, having full knowledge of the law. The exact same principles that have worked against you can work for you, but only when you rebut their presumption and reclaim your sovereign status. In all law, you are either a complete servant debtor or a purely sovereign creditor. There is no such status as a half debtor or half creditor. Any type of action other than the elimination of the presumption of ownership leaves you in the same legal status of a servant and debtor. The only legal method available to repel and rebut the banker's presumption of claim against you is by filing and recording in your real, physical, biological, and sovereign capacity a financing statement in the office of and of every state secretary of state who lays claim and title to your persona. By filing this instrument of claim, you're also securing all other government-based documents with your financing statement. Only a sovereign holds sovereign and allodial title to his property and goods. If you reclaim self-ownership, neither the world power bankers nor anyone else in legal existence can perfect or complete a claim against you. They may try, but once they have knowledge of your perfected financing statement, they cannot continue as they no longer have a standing in law as sovereign over the real you or your persona. The world power brokers have attained their current ownership of the modern world after refining the law merchant for thousands of years. In their own earthly wisdom, they have made everything they did legal according to man's laws. However, life dictates that there are two sides to all things, and this includes laws, rules, process, codes, and regulations. If any law is used in one way, such as against you by your default, it can also be used in the opposite way, such as by your correct use of them. A timeless and universal maxim of law states, the law always gives a remedy. The legal merchants of commerce must leave you a way out, a backdoor for escape. If they don't, then their legitimacy and legal authority becomes a sham, and this would destroy their purported law. No sovereign can rule without the majority consent of the people. Power always has and always will reside in and with the people. People become enjoined to servitude simply because they have chosen to give their power away rather than retain it. Such is the demise in America. If a sufficient number of people in any country become aware of the truth and reclaim their power, no tyrant or government can maintain a sovereign position. Once you have found a financing statement establishing the real and sovereign you as a secured party, you will hold an exclusive claim on your persona or straw man. This places you at the top of the list of creditors, number one, numero uno, above the government and their system. You have ownership to your persona, and no one can attach a claim to either of you. This makes you a legal sovereign, a legal freeman, and immune from all claims. We were not supposed to have knowledge or understanding concerning the open back door of legal remedy. Before 1862, Americans were personally accountable for their actions in common law courts based on the original common law of England prior to 1066. Currently, personae are legally owned property of the government and have become the accountable parties as prejudged and enforced by their private legal system and its rules. Former sovereign Americans are now personally accountable because they have joined by implied contracts to their straw men. The purported judicial courts of today are set up to deal only with artificial entities, such as your persona or a corporation. A sovereign, the real you, the good and lawful Christian, has no place in a contemporary court of commerce and cannot be legally accommodated. Their commercial legal venue is not the venue of a sovereign. Anyone who intends to follow the material presented within this project report must do so only after having a thorough understanding of what has been presented and how their system works. You must obtain knowledge beyond what we have written here. Our report is a mere outline. Spend time in studying the UCC until you comprehend how it works. We suggest very strongly that you begin reading from front to back, A to Z, a good law dictionary. Think of this as a language lessons in order for you to recognize, understand, and speak legalese. In conclusion, we take you back to the opening paragraph of the introduction. But God has chosen the foolish things of the world to confound the wise, and God has chosen the weak things of the world to confound the things which are mighty. 1 Corinthians 2:27. Without God's wisdom, you will never be able to grasp the breadth and height of what has taken place. Man, in his worldly wisdom, thinks that he can fool anyone. The wisdom of the Lord is foolishness to men, just as the wisdom of men is foolishness to God. Legalistic wisdom looks to the letter of the law, but Allah/God's wisdom looks to the meaning. You should do nothing without taking time to pray about this material, the meaning within it, and the truths revealed. Only after this should you proceed to utilize what you have learned. We also suggest you share this material with other Moors and discuss the legal as well as spiritual characteristics that apply. While this report is not legally copyrighted under man's laws, if you wish to publish or reproduce this material for use only among other good and lawful Moors, we ask that you show the Moorish Great Seal Law Institute, lawgiver.org, the Great Seal Moorish Law Institute. For the Allah is our judge, Allah is our lawgiver. The Yeshua Lord is our King. He will save us. Isaiah 30-22.